Hello everyone. Today we'll be studying a 12-point difference between MRTP Act 1969 and Competition Act 2002. The first point of difference meaning the MRTP Act is India's first competition law consisting of laws and regulations that govern discriminatory market practices, whereas Competition Act 2002 was established to encourage and maintain economic competition and protect consumers' interest at marketplace. Second basis, the MRTP Act 1969 was based on pre-liberalization and pre-globalization thesis, whereas the Competition Act 2002 is based on modernized economy after liberalization and globalization. Third objective. The objective of MRTP Act is to prevent concentration of economic power in hands of few, control monopolies, and prevent monopolistic and restrictive trade practices. Whereas the objective of Competition Act is to prevent practices that are having adverse effect on competition and to promote a healthy and ensuring freedom of trade. Fourth purpose of the Act. The purpose of MRTP Act is to prevent monopolistic markets and unjust practices, whereas the purpose of Competition Act is to encourage competition and maintain business autonomy. Fifth nature of the Act. MRTP Act 1969 is reformatory in nature, whereas Competition Act 2002 is punitive in nature. Determination domains. Sixth point. It is determined by the firm's size, whereas in competition law it is determined by the firm's structure. Seventh point, dominance of position. In MRTP Act, entity having status of dominant position is itself considered as bad, whereas in Competition Act, entity having dominant position is not considered bad, whereas abuse of dominant position affecting a consumer's interest is considered to be moral. Eighth point, power. The MRTP Commission has the power to pass only cease and desist orders, whereas in Competition Act, the CCI can order to prevent and punish such as those activities which abuses competition. Ninth point, offenses. The MRTP Act contains 14 offenses that violate the notion of natural justice, whereas in Competition Act it acknowledges only 4 offenses that are regarded to be violative and of the concept of natural justice. 10th point, appointment of the chairman. The central government appoints the head of MRTP Commission, whereas Competition Act, the chairman of CCI is chosen by a panel composed of retired judges and other professionals with expertise from various fields like trade, commerce, industries, finance, and so forth. 11th point, penalty. In MRTP Act, there is no punishment for the violation, whereas in Competition Act, offences are punishable. 12th point, agreement. In MRTP Act, agreement is required to be registered, whereas in Competition Act, it does not specify any provision relating to registration of agreement. Let's discuss a short conclusion between the difference of the two acts. So in short, the two acts are different in a number of contexts, where MRTP Act has a number of loopholes and Competition Act covers all the area which the MRTP Act lacks. The MRTP Commission plays only advisory role. On the other side, CCI Commission has a number of powers which promotes suo motu and levies punishment to those which affects the market in a negative way. Thank you for watching.